Now, good morning, Mr. Adkin.
Good morning, my lord, my lady.
Thank you very much for the very efficient way in which the case has been prepared so far. We have a preliminary issue about your application to add a ground of appeal. Am I right, Mr. Kitchener, that you haven't filed a skeleton argument in response?
We haven't. I do apologise for
No,
the
no, don't
confusion.
apologise. You asked for a certain. Could you let us know by X date whether you would, and then if you would, by Y date, then you would do it. We didn't receive anything, so we assumed that you hadn't.
No,
You're content to rest on the document you already filed.
my solicitors actually did. I know you're not all that concerned, but my solicitors did send an email to the Court of Appeal office on Thursday saying that we weren't intending to.
So there we are. It doesn't matter. Right. What we think we will do on this probably won't come as a surprise to you both. Is that we're going to hear the argument on it, the Bennett essay, and then we'll make a ruling on the application to amend at the end. All right.
My lord, that was the course I was going to proffer as a sensible one.
Yeah. It enables us to have a more flexible look at change of position, whilst coming on back, as it were.
Thank you.
My lord, could I just mention one thing? I'm not going to obviously try and dissuade you from the course that you wish to take. I did discuss with my learned friend that I've got slight concerns about the availability of time in relation to the additional ground. We think that if it has to be argued, Mr. Naden is going to argue the substance, and he'll take, as he did below, we think he'll need probably about an hour for that. I was already planning to have a day for the existing grounds, but my learned friend has explained that he thinks he's going to be quite short. So on that basis, we shouldn't have any difficulty, but I just wanted to raise that in the open.
Thank you. Well, yeah, okay. Right, well, let's get started, Mr. Adkin.
Thank you. There is one matter of housekeeping that I've been asked to raise, and that is that we have an opus transcriber, and we need your permission to.
I've signed something this morning, haven't I? So that's all right.
Thank you very much. My lords, my lady, I appear as Mr. Mohammed Bai for the appellant Rasmala, and my learned friend Mr. Kitchener and Mr. Naden appear for the respondent Trafigura. I will deal with all of the matters apart from the application, and if the application is granted, you're going to in any event the new ground that's being sought. Mr. Mohammed Bai will deal with that. My understanding is that similarly on the other side of the court, my learned friend Mr. Kitchener will deal with everything apart from the application, which Mr. Naden will address. And so the course I propose to adopt is to address you first on the grounds as they exist, and then Mr. Mohammed Bai will take over in relation to the new ground. This is a case, as you know, where the respondent Trafigura was found to have been unjustly enriched at the expense of Rasmala, following the receipt of 5 payments totaling around $22 million made by Rasmala in the period August 2017 to March 2018. But the learned judge, Mr. Justice Raja, found that Trafigura was entitled to rely on a change of position defence, such that it was not required to make restitution of any of the monies that it received. And this appeal is concerned, as you know, with whether the judge was right in that finding that Trafigura was entitled to rely on its change of position defence. Now, the course I propose to adopt is firstly to set out what we say is the relevant background, then briefly to explain the judge's findings in upholding the change of position defence, then summarise the grounds of appeal on which we rely, then set out some of the general legal principles which are engaged in this area of the law, and then develop our submissions by reference to the grounds of appeal in respect with which permission was given in turn. And there are 4 that I will focus on: causation, risk allocation, good faith, and what we say about payment 5. So that is how I intend to proceed. So starting with the relevant background, the judge's findings in relation to that, as you will have seen, are set out in paragraphs 11 to 64 of the judgment. And we have the judgment and we'll be referring to it often in the core bundle at tab 7, page 71, and the judge starts to deal with the background at page 73. There are, of course, 3 players in this story. There is Falk, which was a coal trader that purchased coal from Trafigura. There is Trafigura, a commodities trader that supplied coal to Falk, and there is Rasmala, a finance house which provided Sharia-compliant financing.
Yeah.
And the position, as at 2017, was that Falk had an open credit limit with Trafigura of around $10 million, which one sees from paragraph 14 of the judgment. And by mid-2017, Falk was struggling to remain within that credit limit and was late in making payments. So in other words, Falk owed Trafigura in the region of $10 to $11 million. Although, somewhat oddly, at trial, Trafigura was unable to produce a running account of what Falk owed it at that time, as the judge observed at paragraph 104 of his judgment. Now, around the same time, so July 2017, Falk had negotiated with Rasmala a Sharia law compliant arrangement known as a Muhabaha facility, I'm sure I've mispronounced that, which would provide Falk with access to $20 million, which it could use for coal trading. And the way that was to work, as between Rasmala and Falk, was that Rasmala would purchase the relevant coal from Trafigura, with Falk acting as its agent, and Rasmala would then sell the coal on to Falk at an agreed rate of profit against a binding contract of on sale from Falk to an end buyer. And that particular arrangement was important to Rasmala, both because it would enable Rasmala's position to some extent at least to be secured, and also because it was Sharia law compliant, Rasmala not acting strictly as a lender, but as a buyer.
Yes. You say to some extent to be secured. How?
Against the coal that was
Did
buying.
you get a bill of lading?
I'm not sure.
Did you ever ask for physical delivery or title to the coal, or try and enforce security?
I don't believe so. No, my lord.
So I can see in principle that if you're buying the coal, we'll give you a title to it, which might enable you to recover your advance. But there's nothing in the papers to suggest you ever took any steps to take the security or do anything with it.
Well, in fact, the judge describes the transactions as not working as intended.
Indeed.
Paragraph 21.
Yes, 21 to 23.
Whatever had been intended in relation to title didn't actually happen in practice.
Entirely right. Yes.
So is it fair to say that the security is really illusory in this case?
Yes, the security doesn't eventuate. What I'm trying to do is, as it were, start from what Rasmala originally hoped for and intended.
Yes, but just to be clear, my reading of paragraph 21 is that Rasmala presumably would have been aware that, should have been aware that the transactions weren't working as intended.
I would agree with that, but they were certainly not aware of what was going on as between Falk and
Yes,
Trafigura. But I would accept that Rasmala either should have been or was aware, certainly of some aspects of the way in which, in practice, the arrangement departed from that which was originally intended. I would accept that, but I don't submit it doesn't matter. But at the moment, I'm just, as it were, setting the original scene. And so to take us back into mid-2007, Falk, what happened, and so we can start with the story around payment 1.
2017.
2017, what happened in July 2017 was that Farlin provided Rasmala with a sales contract bearing the number 1475551, which is referred to in the judgment as the 551 contract. Curiously, at paragraph 24 of the judgment, it said that the forged contract was between Farlin and Rasmala. That would appear to be an error. The forged contract was between Farlin and Trafigura for future performance by delivery of and payment for coal.
So in the bottom line on page 75, we should read Trafigura instead
Yes.
of Rasmala, shouldn't we?
Yes, and a copy of the contract in the forged contract exists with Trafigura. Now, in fact, as I said, the contract was a forgery. There was no such contract, although, of course, Rasmala did not know that. Then, in the first half of August 2017, Farlin formally sought to activate the steps with Rasmala under the Murabaha Facility Agreement to obtain financing in respect of that contract, and that resulted in Rasmala making the first of the 5 payments with which this case is concerned, payment 1, which it made directly to Trafigura on the 21st of August 2017 in the sum of $6.4 million. And that payment was, as with all the others, made under a mistake, namely in the mistaken belief on the part of Rasmala that it was being paid in respect of a contract to be performed in the future, which did not in fact exist. Now, turning the focus to the position of Trafigura, Trafigura's receipt of that payment 1 from Rasmala, was the first that it had ever heard of Rasmala or had anything to do with Rasmala. So, as we'll come on to see, Trafigura never had any dealings with Rasmala directly beyond the receipt of the payment. All of its dealings, as you will have seen from the judgment, were conducted with Farlin, including the obtaining of consents, which for the benefit of Farlin and disbenefit of Trafigura. What is clear, and indeed common ground, is that when Trafigura received payment 1 from Rasmala, Trafigura understood rightly that the payment had been made on the basis that it was to be used for contracts to be performed in the future, not for the discharge of Farlin's historic debts. And Trafigura knew, since it was not prepared to deal with Farlin further without those historic debts being paid down, that unless it obtained Rasmala's consent to use the payment for a different purpose for that which it had been paid and received on its understanding, then the payment would have to be returned to Rasmala. And we'll have a look at the evidence in a moment. It's a point of some importance, and we can see it reflected in paragraph 95 of the judgment. So if we take that up, this is page 89, in the part of the judgment where the judge is dealing with the change of position to defend in particular causation, and we'll look at this very carefully in due course. And the judge says, Rasmala contends that Trafigura relied upon the TPAs to discharge Farlin's historic debts, and so its change of position was caused by the TPAs and not the receipt of the payments. In relation to payment 1, Trafigura knew that Rasmala had not made the payment to discharge Farlin's historic debts. Trafigura's witnesses confirmed that if Farlin had not provided a TPA purportedly signed by Rasmala for payment 1, the payment would have been returned to Rasmala. And that's not just the judge summarising the evidence, because that is common ground. And we can see that from what my learned friends say in their appeal skeleton at tab 3 of the call bundle, page 50, paragraph 49, subparagraph 2, we can start there. Second sentence, it is correct that Rasmala made payment 1 for the purpose of financing specific future shipments, and that Trafigura knew this. So that's accepted. I think the position is said to be different in relation to later payments, and we'll come on to those. But just to make the point good again, at page 54 of my learned friend's skeleton, paragraph 51(1), they refer to Mr. Gakale's evidence, that's a Trafigura witness, was that he understood that payment 1 was intended to be allocated to a specific future deal, and that if a TPA was not obtained, the money would need to be returned. So that is a common ground, and it appears that the reason that Trafigura knew that without the further agreement of Rasmala, Trafigura could not use the monies it had received to pay down Farlin's past debts and would have to return them to Rasmala, was because that is what it had been told correctly by Farlin. Now, the judge's reference to what Trafigura's witnesses said in their evidence was, of course, right, and it is worth just briefly looking at the evidence of one of those witnesses, Mr. Maru, who was the Trafigura credit manager dealing with the Farlin account. He was cross-examined about this, and we can pick it up in the supplementary bundle at tab 6. So this is the transcript from the trial, and if we go to tab 6, page 142, have a look at internal page 26, line 23. We can pick it up there. So this is Mr. Maru's evidence in cross-examination, and he's referred to, I think, the TPA at the bottom of page, internal page 26, line 23. Yes. And if we go over, he's asked, so what is being envisaged at this stage is Miss Gordon, that was the Trafigura in-house lawyer, explained in her email. So what is being envisaged, as you understand it at this time, was that the monies would be applied to a specific credit for the future delivery of coal. Agreed? The draft contract was worded in a way it would be applied for future. Yes. But we had outstanding dues, and we wouldn't have let deliveries on that future contract until the existing dues were cleared. So contractually, we needed the right to allocate those funds to the current outstanding. Otherwise, we would not have allowed delivery under the future date, and that's obviously
just the reference to the draft contract there.
That is the TPA, I believe.
Oh, it's the TPA.
Yes.
Because the forged contracts were obviously not.
The forged contracts didn't cross the line.
Yes.
So the forged contracts were on the Rasmala side of the fence.
So
But
this
the
is
TPA, which also didn't cross the line, but that
one.
was confined to the other side of the fence, to the Trafigura side of the fence. And here we're talking about the TPA. And we'll have a look at.
We're actually talking about an earlier draft of
Exactly.
the TPA.
Exactly. And we'll have a look at the final version of the TPA. Let me perhaps just take a little excursion. There were TPAs prepared in respect of each of the 5 payments. In relation to the first 4 payments, as you may have picked up, the TPAs were executed, and you need to put that in inverted commas because the execution, i.e. the signature and stamp of Rasmala was forged, was faked. In relation to the 5th payment, although a TPA was asked for, it was never in fact executed, whether genuinely or by way of a forgery. But to get the process underway, because remember we're looking here at payment 1, there is a process of the in-house lawyer drafting the TPAs, and that is what my Lord Justice Nugee is quite right. What is being asked about here, I believe, is a draft of what was to become the TPA in respect of payment 1. And that draft underwent a very important change because in its original iteration, it was intended to allow the payments to be used for future contracts. In its final iteration, it had changed to allow the payments to be used in respect of past contracts paying down Farlin's accrued debts. And that's the difference between something that Rasmala was willing to allow and something that it had not been willing to allow. But we'll come on to that at a later stage of the analysis. But the significant point for now is just to understand what Mr. Maru of Trafigura is saying in the middle of internal page 27. We had outstanding dues and we wouldn't have let deliveries on the future contract until the existing dues were cleared. So contractually, we needed the right to allocate those funds to the current outstanding. Otherwise, we would not have allowed delivery under the future date. Question, I completely understand. That is a very fair answer, Mr. Maru. You're saying that we will come to your understanding in a minute, but whatever Ms. Gordon was doing, applying it to a specific contract for the future delivery of sales, you as the credit manager wanted to apply those monies to historic debts because you were owed a lot of money by Farlin. That is correct. I'm not myself criticising that in and of itself. We will come to the criticisms later. So can we just, for the purposes of this cross-examination, call that the first draft that we have looked at, and the first idea, this is the first draft of the TPA payment one, which is to apply the money in respect of a specific contract for the future delivery of coal. Right. Then let's see what happens in that context. If we could go back to, and he's taken back to another document, to the an email. Harsh, so she is informing Mr. Shazani. I've discussed this further with Rajat and Roadmap. That Rajat is you, isn't it? Yes, that is me. We've discussed this. The document has been drafted on the basis of funds as payments in respect of future shipments rather than present outstanding payments. So that was how it had been drafted. That was the document we looked at, wasn't it? Yes. And she says, Miss Gordon, which I understand is the basis upon which Rasmala has made this payment. And again, I'm not criticising you, Mr. LaRue, but I'm just saying that you understand at this time that the basis upon which Rasmala has made the payment was for a specific contract for a future shipment, and you wanted to apply it for a different purpose. I may not have put it on that angle at that point of time, but I was very clear that if we had received any payment, that payment should have been allocated towards existing overdues. Even if the finance house had wanted to apply to a future contract, a specific, can you say again? Even if the finance house had wanted to apply to a specific contract for future delivery, in that case we would not have accepted the payment and returned the payment, or we would have asked Farlin to make good the existing dues before we deliver on anything further. Mr. Maria, I'm going to have to push you a little bit on this because it's quite obvious, isn't it, from this email, that Trafigura understood that the basis, and you understood that the basis upon which Rasmala had made the payment was for a specific contract for future delivery of coal. You understood that, didn't you, Mr. Maru? I had not paid attention to future delivery of coal at that moment. My attention was that we had refused payment from Rasmala, and if we had received payment from a third party, we have tick boxes internally to take care of. And one of the tick boxes was credit. Credit had a very clear view that we will not accept this payment unless it is applied towards historic payment. I'm going to push you a little bit further by reference to the email at the top, and then you've taken to the reference. So Trafigura over the page. Trafigura well understood the basis of the payment was prepayment for a future delivery. Yes, the legal in Trafigura must have understood it, but you might not have specifically, but someone, yes, that is a fair answer. Okay, thank you. But you intervened, don't you? Let's go back to the email of Alex Gordon, please, if we could highlight operator email in the middle. You intervened. I have discussed this further with Rajat and Ronak. She says it had been drafted on the basis of future payments, which she understood was the basis. And she says in the second substantive section, sentence, following discussions, I have amended this in the attached on the basis that the funds paid by Rasmala may cover both present outstanding payments, including demurrage, and payments in respect of future shipments. So you had discussed with Miss Gordon and you had said that whatever basis Rasmala had made the payments for, Trafigura wanted to apply it to historic debts, and a draft tripartite agreement should be produced, which would allow Trafigura to do that. Fair summary? Yes.
To whom did that email go, this email that is being read out there?
So this is all internal Trafigura.
So this is Ms. Gordon to
Exactly.
somebody in
Exactly.
Right.
Exactly. This is all internal Trafigura. And Miss Gordon says that you can do that. She advises that you can do that if Rasmala and Farlin agree. Yes. And I'm not suggesting that you didn't realise that. You obviously believed that Rasmala had agreed. Yes. So I'm not criticising you, Mr. Murray, but I'm just trying to work through the basis of how you proceeded. You understood at the time that you could do this, but only if Rasmala agreed. Yes. And then he's taken to his evidence. And you can read that over to the page. That is that. So we can perhaps pick it up again at paragraph 37.
Do we need to look at 33,
y-
line 17?
yes. So
On 33,
yeah,
where he's asked, you understood that
Exactly.
without Rasmala's agreement, you couldn't apply the funds to historic goods, and you'd have to return the money.
yes, I knew that. Thank you, my lord. I don't want to labour the point, but you have it. His evidence was that he understood, and Trafigura understood, on receipt of payment 1, that it could not be used to pay historic debts without Rasmala's agreement. And if we pick it up again on page 145, internal page 37, we'll see what caused that change. And that's why you sought to change the language of the TPAs, and you checked, didn't you, that Alex Gordon had changed it, right? Yes. And that was because you were relying on the tripart agreement and its validity to allow you to do what you were doing. Yes, Trafigura was relying on the tripart agreement. Now, let's assume for the moment, as they turned out to be, if the tripart agreements were invalid for some reason, or Rasmala had not in fact signed that document, then you understood, didn't you, Trafigura would not be able to keep the money. Yes, I understood that. So, you have the point, and the judge was absolutely right in the finding, of course, that he made at paragraph 95 of the judgment. So, if one just pauses at this part, in this point in the story for a moment, after Trafigura has received payment 1, but before it's done what it says was its change of position, which is to carry on trading with Farlin, what was the situation? The situation was this. Trafigura knew that Rasmala had made payment 1 in respect of contracts to be performed in the future and not to pay down Farlin's past debts. Trafigura also knew, because it was its position, that if Farlin's past debt was not paid down, there would be no further contracts, because it, Trafigura, was not willing to continue trading without the arrears being paid down. And Trafigura knew, again, rightly knew, that it, Trafigura, was not authorised to apply payment 1 to pay down Farlin's accrued debt, and then unless it obtained such authorisation, the payment would have to be repaid. Obtain such authorisation from the payer, Rasmala. So if matters had remained as they stood at that point in time, after receipt of the payment, before the change of position, the payment would have been repaid and Trafigura would have ceased trading with Farlin. The reason that did not happen was a further development, namely the presentation to Trafigura of a third-party agreement, or TPA, under which Rasmala purportedly agreed to payment 1 being used for a different purpose to that which both it, Rasmala, and Trafigura understood and intended that payment had been paid. And it's worth just briefly having a look at how that third-party agreement, that TPA, came about. And the judge addressed this part of the story. We've already seen a little bit of it in the cross-examination of Mr. LaRue, but the judge addressed this part of the story at paragraphs 32 to 37 of the judgment. If we look in the core bundle at tab 7, we can pick it up at page 77. And it's addressed starting at paragraph 32. On the 23rd of August 2017, Ms. Gordon responded, providing a draft TPA following discussions with Ms. Jazani. So this is all internal Trafigura.
Yes.
Ms. Gordon plainly understood from Mr. Jazani that payment one was intended for specific future payments. The relevant part of her email said, please note that I have drafted this on the basis that the fund paid to Trafigura are to be applied towards specific shipments under the various trades. I need your clarity on which shipments these will be, since this should be recorded in the document. This means that the document does not allow for a blanket third-party agent type structure to be used going forward, which I understand is not the commercial intent in any case. However, after an intervention by Mr. Maru, Ms. Gordon revised the draft TPA so that Trafigura could use payment one to cover outstanding payments due, as well as payment in respect of future shipments. A covering email made clear that her understanding was that this was not the basis upon which the payments had been made by Rasmala, and that Rasmala and Farlin would have to agree to this revised wording. And of course, that was absolutely right, factually and legally. Mr. Jazani emailed Mr. Samdani of Farlin, attaching the updated version of the TPA, and explained, we have cited the payment of 6.84 million, so that's payment one. Thank you for the same. However, we have received the same from unrelated party Rasmala, which complicates the situation. We are unable to allocate the payment towards Farlin outstanding, since Rasmala Fund is not a counterparty on any contract between Trafigura and Farlin. We understand that Rasmala are financing your trades, and hence our legal team has drafted a tripartite agreement that elucidates the funds received after future shipments of Alam Jaya, for which we have entered into a term contract, however, can be used to offset old outstanding, including demurrage. Appreciate if you can get the same signed by Rasmala as well as Farlin and send the same back to us. Farlin initially pushed back. Mr. Sandana's email on the 23rd of August 2017 made a number of points and contained a sentence on which Rasmala now relies very heavily. He says that Rasmala was just financing the deal and they will never sign any tripartite agreement allowing offset of this money, again, existing liability, including demurrages. And just pausing there, again, jolly good reasons why he would say that. It was true. His email entreated Mr. Jazani to treat the money as a security deposit while Farlin cleared its outstanding debts within the next 3 weeks, at which point it could be returned to Rasmala or used against some ongoing contract. Mr. Gokhale's evidence, that's another Trafigura witness, was that there were discussions between Mr. Jazani and Mr. Samdani, who relented and eventually confirmed that Rasmala had agreed to the allocation of payment one to Farlin's outstanding dues. Farlin sent back a revised draft TPA with amendments, one of which was material to the fraud being perpetrated. Clause 5 of Ms. Gordon's draft was amended so that Trafigura was authorised to communicate only with Farlin, such communication being deemed to have been received by Rasmala. On the 28th of August 2017, Farlin provided Trafigura a final version of the TPA, TPA1, which was signed by Farlin and purportedly signed by Rasmala. In fact, Rasmala was oblivious to these communications about TPA. Its signature to TPA1 had been forged. In line with TPA1, payment one was allocated by Trafigura to the discharge of Farlin's oldest debts, described by Trafigura's witnesses as a first in, first out or FIFO basis. The effect of this payment was to bring Farlin's exposure within the credit limit set by Trafigura, and so Trafigura continued to trade with Farlin. Now,
It's a very small quibble, but I think when it says, the judge says the effect of this payment, I think it's the effect of the allocation.
that is, that with respect to my lady, the absolute bullseye, nail on the head point of this.
Yeah.
That's where the judge goes wrong, because causatively, what happened was not they received the payment, and on the faith of the payment, they carried on trading with Farlin. Causatively, what happened is they received the payment, they knew that it was for a particular purpose. That purpose is one which would not have permitted them to carry on trading with Farlin. They were only willing to carry on trading with Farlin if its historic debts were paid down. And what caused the payment down of the historic debts was the allocation, or the belief that there had been an allocation to those historic debts. And what caused the belief that there had been an allocation to those historic debts was the forged signature of Rasmala on the TPA agreeing to that allocation. So when you ask what was the cause of the change of position,
We're getting ahead of ourselves.
we'll come to that, and I'm going to go, but I just, your ladyship has zoomed into the point, and that is the point. That's our case on causation. But we are getting ahead of ourselves, and we'll come back to it. Now, I said I'd show you the TPA in relation to payment 1. That's in the call bundle at tab 13. And it is worth just having a look at this, but we have to keep in our minds as we do that this document is a forgery in the sense that the critical signature on it, Rasmala's signature, which we see at the end, and Rasmala's stamp, Rasmala had absolutely nothing to do with. This is Farlin's forgery of Rasmala.
This is the forged document.
So it's a genuine document in the sense
Forged
that it existed, it was handed over to Trafigura, but it's a forged signature, as Nigel said. So we have the parties, so we've got the date, we've got the parties, Trafigura, Farlin and Rasmala. And then it says, whereas Trafigura and the counterparty have entered into a number of contracts, so counterparty is Farlin, have entered into a number of contracts with the following deal reference numbers: 237168, 233517, for the sale and purchase of coal as amended from time to time. Just pausing there, it will be helpful to you if I explain that the deal numbers in that recital A correspond to historic contracts between Trafigura and Farlin. That is to say, contracts which had been performed, but in respect of which arrears were owing by Farlin to Trafigura. I don't think I need to take you through where you get that, but it's pleaded out, just for your note perhaps, in paragraph 38.6 of the defence in the call bundle at tab 11, page 150, and in schedule 1 of the defence at page 184 of the call bundle. But returning to the TPA, so recital B, under the contracts, Trafigura and the counterparty agreed or are to agreed.
Sorry, which version are you on? I'm
I'm so sorry. So we're in the call bundle.
Oh, you're in the call one.
Call bundle.
Page 210.
Oh,
exactly.
I'm sorry. I was
Are you operating? If I may ask, are you operating on hard copy or
Hard electronic.
right? Okay.
But also, you might move about between the two. So
I shall cater for all eventualities.
no doubt, pagination is exactly the same on all the bundles.
Well,
in
let's
accordance with
keep
the
our
master
fingers
rules.
crossed. I hope the only difference is that the hard bundles have tabs and the electronic ones don't, but we'll find out. So yes, we're in page 210 of the call bundle, and we're looking at what the judge called TPA 1. So this is the TPA in relation to payment
And the
1.
two numbers in the first recital are the numbers, as you said, related to historic contracts.
Exactly.
Performed, but in respect of which there were.
Exactly. So historic contracts on which there is an accrued outstanding debt between Farlin and Trafigura. And then recital B, under the contracts, Trafigura and the counterparty agreed or are to agree that Trafigura shall sell and deliver the counterparty, and the counterparty shall purchase and accept delivery of coal. The counterparty, so Farlin, shall appoint the new party, so Rasmala, as a payment agent to perform the counterparty's obligation of payment settlement of the product in respect of the shipments under the contract, that's in fact the historic contract, including but not limited to any demurrage payments incurred in respect of such shipments, in consideration of the benefit that the new party receives or shall receive under the finance arrangement between the counterparty and the new party, in respect of the product the new party, so that's Rasmala, accepts such appointment in respect of the shipment. In this deed, the counterparty and the new party shall record the appointment such that the new party, Rasmala, will be party to the contract and settle payment in respect of the shipments. And then we have the contract itself, and we don't really need to read much beyond paragraph 1. The counterparty, so that is Farlin, hereby appoints the new party, Rasmala, as the payment agent in respect to the shipments, and that's referring to the historic contract shipments, and the new party accepts such appointments to settle payments under the payment clause of the contract, that's the historic contract, in respect to the shipments. Trafigura and the counterparty accept that such settlement will be made by the new party subject to the terms stated herein. Perhaps we can just pick up over the page one clause which the judge noted as well. Clause 5, Trafigura may communicate only with the counterparty, i.e. Farlin. Any communication sent to the counterparty shall be deemed to have been received by the other. And then at the end of the document on page 212, we see the purported, but in fact forged, signature on behalf of Rasmala.
Just
So-
to clarify, the discussions or the evidence of discussions we saw suggested that the final version of the document would allow allocation to either historic or
Yes.
future deliveries. I'm not seeing that at the moment.
No,
It's just historic, isn't it?
It is
Based
just-
on what you've said.
yes. So that indeed, the I think there's reference to overpayments.
Clause 4.
That's clause 4. That may not.
It may not matter, but
It may not matter.
it's purporting to say to make payment for those two specific, as you say, historic contracts.
Yes. And that's how all of these GPAs work. I agree, my lady. One struggles to see the future payment piece. These two contracts are historic contracts. And that is what it's purporting to deal with. And in fact, none of the payments is used in any other way than to pay off historic accrued debts.
Well, purport to at least.
And I'm falling into the same error as the judge. None of the payments is in the minds of Trafigura allocated
Yeah.
to pay for contracts to be performed in the future. They are all in the minds of Trafigura allocated to pay for historic accrued debts which Farlin has run up with Trafigura in order to bring Farlin within its credit limit. So that's how it worked. And of course, as the judge noted, and as your lordships and your ladyship knows, Rasmala was completely oblivious to this TPA and all of the TPAs. It had absolutely nothing to do with it at all. But it was a critical step because that is what caused Trafigura to believe that it had allocated the monies to pay off the historic debts, and that was the step which Trafigura understood and intended had to happen in order to unlock continued trading with Farlin.
Can we just go back to paragraph 36 of the judgment?
Yes.
And I hope I'm not being too slow here, Mr. Adkin, where this is described, isn't it?
Yes.
Led up to it.
Yes.
Mr. Gokhale's evidence was there were discussions with Mr. Jansani. Mr. Gokhale and Mr. Jansani are both Trafigura,
Yes.
And
Yes.
Mr. Samdani
Is Farlin. Yes.
who is said to have relented.
Yes. It's an odd choice of word, isn't
That's
it?
yes. I'm glad that I'm not. Yeah, it is an odd choice of word.
Yes. Yes. In Trafigura's mind, presumably, it was Rasmala that had relented, because in Trafigura's mind, it was Rasmala's consent that was required to allocate the monies to historic debts. So it is a
Yeah,
curious choice of words.
That is looking at it, as it were, from point
Yes.
of view. Trafigura's point of view.
Yes. Exactly.
Is anything going to turn on that on the appeal?
An awful lot is going to turn on whose point of view you're looking at it
Yes.
from, but I don't think anything turns on the word relented.
No, or that for the evidence of the discussions.
Yes, nothing turns on that. There is no dispute that we don't challenge the judge's findings. I think this is what he's finding. That there were discussions between Trafigura and Farlin, and that those discussions led Trafigura to believe, coupled with that the TPA would be forthcoming, and that Rasmala had changed its mind and was willing to agree to the payment being allocated to historic debts. I think that's all the judge is saying, and that's not in dispute. But it's also not in dispute that this was all a fabrication from Farlin. Rasmala
Yes.
were completely oblivious to all of this.
And there was no direct communication between Trafigura and Rasmala.
There were only 5 direct communications between Rasmala and Trafigura, if you can describe them as that, and they were the payments. There was no other crossing of the line between Rasmala and Trafigura.
There was an email with at least the first payment saying we're sending you $6.8 million.
We'll check that, my lord. I think that was Farlin rather than Rasmala, but we'll double check. And the critical point, as it were, is that there was no direct communication from Rasmala to Trafigura consenting to Rasmala's monies being allocated to pay down the historic Farlin accrued debt.
No direct communication from Rasmala to Trafigura consenting to that,
Yes,
and no direct communication the other way in asking for confirmation. of
exactly.
consent.
Now, it will be said that the reason that there was no direct communication from Trafigura to Rasmala asking for confirmation is because Trafigura had been presented by Farlin with the TPAs which purported to give that confirmation on the part of Rasmala through Rasmala's signature. That's what is said, that's the case. But we say when we come to the good faith element, that is not commercially acceptable conduct, and I'll unpack that part of the argument. But certainly,
The document I was thinking of was at page 303 of the supplemental bundle, which at any rate appears to be written by Rasmala to Trafigura. So I think if you look at 302, it's an attachment to an email from Farlin. Is that a forged document or a real
so
document?
this is from Mr. Pinto. Oh, I'm so sorry. Yes, 302 is from Mr. Pinto, who is Farlin. And yes, 303 is, I believe, Falk.
Do we think that's forged, or do you think that's...
In relation to 303.
Well, this is dealt with, I hope this is helpful, in paragraphs 27, 28 and 29 of the judgment.
Thank you.
Yes, I'm so sorry. Forgive me. I'm getting myself in a muddle. This is a letter from Rasmala to Farlin, which is then passed to Trafigura. I think that is correct.
Yes, and it's been manipulated.
And this is exactly, that's yes. Forgive me, my recollection was correct. This is a letter that is genuine in the sense that it originated with Rasmala. It was passed to Farlin, but it was then, I think I'm right in saying, manipulated by Farlin before it was passed on from Farlin to Trafigura. And you see that. I'm grateful for my learned friend.
We're seeing the manipulated version.
So we're seeing the manipulated version.
Do we have the unmanipulated version?
I don't
anyway?
believe we do. But my learned friend will correct
I
me.
don't think we have it in the bundles, as I say, that refers specifically to the 551 contract. As you'll see, it's addressed to Trafigura.
So is that signature then is original, is it? At the bottom of the letter on 303?
Yeah, I think so.
I can't assist you, I'm afraid, my lord, on
There's
that.
just a sentence. I have a recollection of the letter. There's just a sentence that's deleted at the end of the middle paragraph that says,
Yeah.
this is in respect of specific.
After Emirates.
Yeah, we can, if you're interested, we could get hold of it.
Well, probably doesn't matter, but
Yes.
okay, thank you.
What is going on is that Rasmala thinks that it is paying for future contracts. That's a problem for Farlin because Trafigura isn't willing to carry on trading on that basis. It's got to have Farlin's debts paid down. And so Farlin is forging the signature on the TPA to give Trafigura the impression that Rasmala has consented to Trafigura allocating the monies that it's receiving from Rasmala to historic debts. That's what's happening. And the critical point that we'll come back to, as I said, is that without that forged TPA, Trafigura would not have changed its position. Now, that's payment one. There then followed a series of
Sorry,
four...
just to go back. We got into this because you said that there were only 5 direct communications between Rasmala and Trafigura, and they were the payments.
Yes, everything else
Does
is...
that mean that
Sorry.
in respect of the other 4, we've seen what's happened with payment 1,
Yeah.
which is that Rasmala did write to Trafigura, but they left it to Falk to send it on, and
Yeah.
Falk manipulated it.
Yeah.
But in relation to the other 4 payments, does Rasmala not communicate at all with Trafigura? Just sent them
No.
in?
So neither Rasmala, Rasmala, can I check that? But everything is going through Falk, apart from the payment. Everything is going through Falk.
So it just sends money to the Deutsche Bank account with no explanation at all, leaving it to Falk to explain the payment.
Yeah.
Thank you.
And conversely, Trafigura receives money into its bank account with no direct communication with Rasmala. And we'll come on to how that all works in due course. So I've addressed you on payment 1. Payments 2 to 4, a series of 4 further payments from Rasmala to Trafigura, which followed the same pattern, though with one important distinction in relation to the 5th payment, payment 5. Now, it's right to note the judge's finding at the end of paragraph 43 that Mr. Gokhale, so this is page 79 of the core bundle, that Mr. Gokhale and Mr. Gupta of Trafigura, at least, did not realise after payment 1 that Rasmala was making its payments in respect of a specific contract to be performed in the future, which was in fact the basis upon which Rasmala was making the payments. So it is right to note that finding. So the situation in that respect, so far as those 2 individuals at least are concerned, is different from payment 1. They didn't realise that Rasmala was making its payments in respect of a specific contract to be performed in the future. But there is no doubt that Trafigura continued to understand that it required Rasmala's consent to use the payments in the way that it did, because after each payment was made, but before it was allocated in Trafigura's mind, it sought that consent in the form of the TPAs. And this was confirmed again in the evidence of Mr. Maru. And it's worth having a look briefly at what he said in cross-examination, this time about payments 2 to 4, and we can pick it up in the supplementary bundle at tab 6 at page 146. Internal page 43. At line 19. So this is the cross-examination of Mr. Maru again. And
I'm sorry, could you just give that reference again?
of course, it's a core bundle, tab 6, page 146. I'm so sorry, forgive me.
Supplemental bundle.
Supplementary bundle, tab 6, page 146, at internal page 43.
Thank you.
So, Mr. Murray has asked, we're on the 3rd topic now, so picking up at line 20, we're on the 3rd topic now. You will be finished well before lunch, you will be pleased to hear, the 2nd to 5th payments. Can we go to F311, paragraph 48? So this is his witness statement. And then he's asked about his witness statement. And then if we go over to internal page 45, Mr. Maru, it says, picking it up at line 3, I see. You say that you believe that Trafigura was entitled to retain those payments. So this is payment 25. And that's because you believe that Rasmala had signed tripartite agreements permitting Trafigura to apply the monies to historic debts. Yes, yes. And if you don't have a tripartite agreement, you return the money. Yes. For any of these agreements, payments that we receive from third parties, we don't allocate the funds until the time we have a tripartite agreement signed.
Can we just pause there,
Yes.
because this may not make a difference, but I'm not sure I'm reading this the same way as you're presenting it. My understanding is that Trafigura's practice was to require a tripartite agreement whenever a payment was received from a third party. The point about which debts it was allocated to was effectively an add-on, as I understand it. And that's what's being said here. We need a tripartite agreement because we got a payment from a third party.
Well, it's a matter
It may not matter, but and as you say, in relation to the first payment, it was understood to relate to future contracts. But I'm not picking up the same point.
No, and I'm not seeking to make precisely the same point, which is why I drew your attention to paragraph 43 of the judgment. So at this point in time, Trafigura is not operating on the judge's finding on the belief that the receipts from Rasmala are for future payments. Did your ladyship recall we looked at that final sentence in paragraph 43 of the judgment? So it's not operating on the same belief it was operating on in respect of payment 1. So it is, in that respect, different to the situation in relation to payment 1.
Yeah.
But it's the same in this regard, that if Trafigura does not get a signed TPA authorising it to allocate the payments as it wishes to allocate them, then the payments are returned. And we see that from the question at lines 3 onwards. I see, you say that you believe that Trafigura is entitled to retain those payments, and that's because you believe that Rasmala had signed tripartite agreements permitting Trafigura to apply their monies to historic debts. Yes, yes. And if you don't have a tripartite agreement, you return the money. Yes. Now, it may be, although I think I'm right in saying the evidence was that it was quite unusual, certainly for Mr. Maru, to get payments from third parties, but it may be the case that that was the position in relation to any payment it received from a third party.
Yes,
it would never allocate.
That's precisely my understanding.
Exactly, that's your ladyship.
Supported by the answer at 11 to 13.
Exactly.
But I think it's supported by other evidence.
But I do.
It may not matter.
My submission is that it doesn't, and that to characterise it as an add-on is not, when is looking at causation, quite right in my submission. It's critical. If they don't get signed authority from Rasmala to allocate the payments to the historic debt, then, well, we don't even need those last few words. If they don't get signed authority from Rasmala to allocate the payments, full stop, the money is returned. And if they don't get signed authority from Rasmala to allocate the payments and the money is returned, there is no change of position, because the change of position only comes about because Trafigura is willing, on the face of the monies having been allocated to pay down the historic debts, to continue to trade with Falk. So in our submission, from the perspective of causation, it actually makes no difference whether you're talking about payment 1 or payments 2 to 5. The causative step is not the payments, it's the allocation, and the allocation is a consequence of the receipt of the TPAs. I can just show you what Mr. Gokhale said. We can pick that up in the supplemental bundle at tab 7, at page 198. If we look at internal, this is a short piece, internal page 69, you must have understood that internal page 69, lines 5 to 9, you must have understood that whatever the basis, you would need Rasmala's agreement in order to apply the monies to historic debt. Yes, as was the case with the first and the second TPA, this was the third TPA. So the position is all the way through, Trafigura's understanding is it needs the signed TPA, it needs the signed authority from Rasmala in order to allocate the monies. And it believed that it had lawfully allocated those monies and was therefore willing to carry on trading with Farlin on the face of the TPAs. Now, the TPAs were forthcoming in relation to payments 1 to 4. So again, Rasmala's signature to each of them was forged. But we now turn to payment 5, the last payment, and there the position is different. That payment, which was in the substantial sum of $4,386,000, was made on the 21st of March 2018. In respect of that payment, as with the others, a TPA was sought by Trafigura, so it asked for one. But in the case of payment 5, Trafigura was willing to allocate the payment to pay down the accrued debt without having a TPA in its hand. In other words, and we see this in the judgment, paragraph 56, it was willing to act on the assumption that a TPA would be forthcoming, or to put it another way, to take the risk that its assumption might turn out to be wrong. And in the event, no such TPA was forthcoming in respect of that last payment, whether containing a forged signature of Rasmala or not, despite a TPA having been requested. But the matter wasn't in the event followed up, because as events turned out, payment 5 was the last payment from Rasmala to Trafigura, since Farlin ceased trading with Trafigura without any other payments being made. So that's where the story of the payments ends. Now, at the time that the trading relationship between Farlin and Trafigura ceased, Trafigura was owed just under $12 million by Farlin, together with charges for demurrage. And you see that at paragraph 58 of the judgment. And Rasmala was also owed substantial sums by Farlin and developed concerns about the monies it had transferred to Trafigura. It contacted Trafigura in 2018, asked a series of questions. Trafigura gave no response. And then in the next year, 2019, following, it seems, a tip-off from a Farlin whistleblower, a representative of Rasmala met with Trafigura's counsel, and in 2020, it finally received confirmation from Trafigura that at least some of the contracts in respect of which it had made the payments were bogus. It turned out that they all were. And to complete the picture, Rasmala did receive some funds from Farlin in respect of the payments, and the result is that the total amount claimed is $11 million, $11,033,295.
So what's that 11 million figure?
11,033,295.
What is it?
So what's it a product of? So that is
not what it's a product of, but what is 11 million?
The claim.
so the claim,
Whose claim?
Rasmala's claim.
Right.
So Rasmala made some recoveries from Farlin. I think the judge notes this in the final paragraph of his judgment. The argument below was that those recoveries didn't need to be allocated in respect of the payments that it had made. That argument has not been pursued on appeal. So the net result is that...
Yeah, that wasn't very clear, I think, from the judgment. So
yes.
Rasmala initially said we don't have to give credit, those receipts
Yes,
from Farling, it now accepts
yes,
that it does. So its net claim is the 11 million odd.
exactly. 11,033,295. Yes. So the
So
judge.
the total amount you sent was 22 million,
Yes.
but you've had half of that back
Yes.
from Farling.
Yes.
Right.
Or give or take. And my lady's point is absolutely right. The judge, in his final paragraph, talked about these repayments and their allocations and reallocations. Decided he didn't need to decide the point because he decided that the restitution claim failed. But he said if he had needed to decide the point, then he would have found against Rasmala on that issue as well. And we don't debate. We don't seek to challenge that conclusion.
The explanation for that, just for your note, is at paragraph 63. Or
Yes.
The facts are set out in paragraph 63.
Yeah. So that's where one gets to the issue. Thank you. Now, as your lordship and ladyship know, the judge upheld the change of position defence, and we can pick up the judgment, call bundle tab 7, page 71. The key findings can be summarised very briefly. Having summarised the facts, and we've looked at those, and then addressed at page 83, paragraph 65 to page 86, paragraph 77, the unfortunate allegations of dishonesty made below against one of Trafigura's former employees, the judge turned to deal with the unjust enrichment claim at page 86, paragraph 78, and he found that paragraph 79 was common ground that Trafigura had been enriched as a result of the 5 payments, and he also found that paragraphs 86 and 87 that the enrichment had been at Rasmala's expense, rejecting the suggestion that the payments had in fact discharged Farling's debt. They hadn't. And the judge also found paragraphs 88 to 90 that one of the unjust factors was present sufficient to ground restitution because the payments had been made by Rasmala under a mistake, namely a mistaken belief that it was paying to acquire coal under genuine contracts, whereas there were no such contracts. And at paragraphs 91 to 92, the judge rejected the submission advanced by Trafigura that good consideration had been given, rejecting again the contention that Farling's debts had been discharged and noting that Rasmala had not made the payments intending to discharge Farling's historic debts, but had made the payments intending to purchase coal pursuant to the Moore arrangement. And having made those findings, it's common ground that the burden then shifted to Trafigura to make out its change of position defence, and the judge addressed that defence from from page 89, paragraph 93 onwards. And he considered 3 different aspects of the defence, and we will be troubling you or seeking to trouble you with all 3 of them. There is the question of causation, which he approached on a but-for basis, as the heading above paragraph 94 indicates. There's the question of detriment, which he addressed at paragraphs 103 to 108, and there's the good faith requirement, which he addressed at paragraphs 109 to 113. And it is these parts of the judgment which are under appeal, and we'll turn to look at them in some detail by reference to the different grounds of appeal. And I want to summarise those grounds of appeal before we get into each of them in turn. We say that the judge was wrong to conclude that Trafigura had made good its change of position defence for 4 reasons, plus, of course, the detriment point, which your lordships and ladyship may or may not entertain. And they reflect the grounds of appeal in respect to which Lord Justice Miles gave permission. First, the judge was wrong to conclude that the payments had caused Trafigura's change of position. That's ground 2 of the grounds of appeal. We submit that the cause of the change of position was Trafigura's belief that the monies received from Farling could be and had been properly paid down against Farland's accrued debt. That belief was not brought about by the payments, which were not made or received on that basis, but was brought about by the TPAs, or in the case of payment 5, was brought about by an assumption that a TPA would be forthcoming. And those, the belief on the part of Trafigura is one for which, of course, Rasmala is in no way responsible, having had nothing whatsoever to do with the TPA. We say the judge wrongly assumed that all was required to be shown was that, but for the payments having been made, the change of position would not have happened. We say that in a case such as this, where the change of position is the result of a voluntary action taken by the recipient on the basis of a belief brought about not by the receipt of the payment but by the subsequent acts of a third party, that but-for approach is inapposite, and the judge should have concluded that the necessary causal link required to make out the defence was not established in this case. Second, we submit that the judge was wrong to conclude, as he did, that it was Rasmala that should bear the risk of the invalidity of the TPAs. That is ground 3 of the appeal. We submit in a case such as this, the defence of change of position may require it to be decided whether the recipient of the mistaken payment should bear the risk that he or she may not be entitled to the money. Trafigura should, we say, bear the risk in this case because it knew it needed to obtain Rasmala's consent before it could apply the payments, as it did. It knew, or must be taken to have known, that if the TPAs were invalid, it would have to return the monies, and it was the only party that could mitigate that risk because Rasmala was not even aware of the existence of the TPAs. Third, we submit that the judge was wrong to conclude that the good faith element of the change of position defence was made out. That is ground 4 of the grounds of appeal. We submit that good faith in this context is not confined to cases of dishonesty, but is a more flexible contract serving the overarching object of whether or not it would be inequitable to require restitution to be made. And it encompasses, we submit, the issue of whether the recipient has acted in a commercially acceptable manner. The judge confined himself to a consideration of the narrow question of whether Trafigura suspected or should have suspected that Rasmala's signatures on the TPAs were forged. But in our submission, the question of whether Trafigura acted in good faith in the relevant sense involved the broader question of whether it acted in a commercially acceptable manner, irrespective of whether it suspected or should have suspected the forgery. And we say in the present case that it did not. A commercial operator who is aware that the payer of monies has only agreed to those monies being used for a particular purpose does not, we suggest, act in a commercially acceptable manner if it fails to contact the payer direct to confirm its consent to the use of the monies, but instead relies solely on what it is told by a third party which is to benefit from those monies. Fourth, we submit that the judge was wrong to conclude that Trafigura did not take the risk that payment 5 should be returned. In relation to payment 5, as with the other payments, Trafigura's change of position is said to have come about because it believed payment 5 could be allocated to pay down Farland's debts. And again, as with the other payments, it knew and understood when it received payment 5 that it would need to obtain Rasmala's consent to allocate the payments for that purpose. However, unlike the position with the other payments, in respect of payment 5, Trafigura did not, as you know, receive a TPA at all, fake or genuine. Instead, it allocated the payment and therefore changed its position by carrying on trading with purported to allocate the payment and therefore changed its position by carrying on trading with Trafigura on the basis of an assumption that it would receive a TPA, and in operating in that way, it took the risk that it would not in the event be authorised to act in that manner. The cause of Trafigura's position in relation to payment 5 was neither the payment itself nor the fraudulent TPA. It was an assumption that Trafigura took upon itself to make, and as I say, in acting on the assumption, Trafigura took the risk that the assumption might be wrong. Now, you will have noticed, you may have noticed, that I have not referred to ground one of the grounds of appeal. That ground is that the judge was wrong to conclude that Trafigura was entitled to keep the payments and treat them as its own. And that is a reference to what was said by the judge at paragraph 101 of the judgment. To the extent that the judge found that Trafigura was, absent a change of position defence, entitled at law to keep the money it received from Rasmala and treated it as its own, that finding is obviously wrong and inconsistent with the judge's previous finding that the payments had not, as a matter of law, discharged Farlin's debts. But we think, in fact, that what the judge was seeking to express in paragraph 101, and this reflects an intervention of my lady a little earlier on a different part of the judgment, is that Trafigura believed that it was entitled to treat the money as its own by paying off Farlin's historic debt. And of course, that is right insofar as it goes. That
So,
belief.
in summary, you're not pursuing ground one.
Correct. And we understand that the explanation I have given for paragraph 101 is shared by those representing Trafigura. In other words, paragraph 101 is just expressing what the judge was finding as to Trafigura's belief in the relevant part. So I need to leave that no further. So we'll go through those four grounds. But before I get to them, I want to turn, I hope helpfully, to identify the foundational principles underpinning the change of position defence. And before I do that, I wonder if I should mention whether it had been intended that there would be a break for the stenographer, and apologies for not having raised that at the start.
The general practice in this court is not to
I
do
see.
that.
Well, I shall clown it. The general principles that we found in the foundational authority, which established that defence in English law, namely the decision of the House of Lords in Lipton, Gorman and Carpnail, and they've been helpfully developed in the more recent decision of this court in Havers and Commune against Deptford Bank. Lipkin Gorman we have at tab 2, page 32 of the authority bundle. The facts of the case are very well known. I can summarise them very briefly. A partner of a firm of solicitors, a Mr. Cass, stole money from the firm, used the money to gamble at the defendant gaming club. The solicitors sought to recover the whole of the amount of what he had gambled from the club. The club said it had changed its position as the result put on by Mr. Cass, so that it would be unjust to order it to repay any of the money. Some of Mr. Cass's bets had succeeded, others had not, there having been more losses than gains, and the House of Lords held that the club was in principle obliged to return the money, but on the facts, the just result would be that they should pay that the amount of winnings that they had paid to Mr. Cash should be deducted from the total amount of bets put on, so that the solicitors would recover only the net sum. And there are two principal speeches, Lords Templeman and Goff, with whom the rest of the House in relevant parts agreed. And we can start with Lord Goff's speech, which states the broad principle on which the change of position defence is based, and we can pick it up at page 62C. It's the middle paragraph. I accept that the solicitor's claim in the present case is founded upon the unjust enrichment of the club and can only succeed if, in accordance with the principles of the law of restitution, the club was indeed unjustly enriched at the expense of the solicitors. The claim for money hadn't received is not, as I have previously mentioned, founded upon any wrong committed by the club against the solicitors, but it does not, in my opinion, follow that the court has carte blanche to reject the solicitor's claim simply because it thinks it unfair or unjust in the circumstances to grant recovery. The recovery of money in restitution is not, as a general rule, a matter of discretion for the court. The claim to recover money at common law is made as a matter of right, and even though the underlying principle of recovery is the principle of unjust enrichment, nevertheless, where recovery is denied, it is denied on the basis of legal principle. And then we could skip to F. Whether change of position is or should be recognised as a defence to claims and restitution is a subject that has been much debated in the books. It is, however, a matter on which there is a remarkable unanimity of view, the consensus being to the effect that such a defence should be recognised in English law. I myself am under no doubt that this is right, and so the defence came to be. And then if we go to page 63F,
Passing over Lord Mansfield.
Passing over Lord Mansfield, I was always reluctant to do that, but we can get ourselves to really Lord Goth's summary of how, at a high level, the defence is to work. So picking it up at F. In these circumstances, this is right. We should ask ourselves, why do we feel that it would be unjust to allow restitution in cases such as these? The answer must be that where an innocent defendant's position is so changed that he will suffer an injustice if called upon to repay or to repay in full, the injustice of requiring him to so to repay outweighs the injustice of denying the plaintiff restitution. Now that is, one sees that quoted, requoted throughout the authorities. That is the guiding principle, although the extent to which guidance is provided is perhaps a little limited because it leaves some of the more difficult questions unanswered, and we will be asking some of them in this case. If the plaintiff pays money to the defendant under a mistake of fact, and then the defendant then, acting in good faith, pays the money or part of it to charity, it is unjust to require the defendant to make restitution to the extent that he has so changed his position. Likewise, on facts such as those in the present case, if a thief steals my money and pays it to a third party who gives it away to charity, that third party should have a good defence to an action for money he hadn't received. In other words, bona fide change of position should of itself be good defence in such cases as these. Now, he refers to the principle having been widespread, and we can skip over that to page 64C. I'm most anxious that in recognising this defence to actions of restitution, nothing should be said at this stage to inhibit the development of the defence on a case-by-case basis in the usual way. It is, of course, plain that the defence is not open to one who has changed his position in bad faith, as where the defendant has paid away the money with knowledge of the facts entitling the plaintiff to restitution, and it is commonly accepted that the defence should not be open to a wrongdoer. And then he observes that these are matters that can be worked out in due course, and we can pick it up again at F. At present, I do not wish to state the principle any less broadly than this, that the defence is available to a person whose position has so changed that it would be inequitable in all circumstances to require him to make restitution, or alternatively to make restitution in full. I wish to stress, however, that the mere fact that the defendant has spent the money, in whole or in part, does not of itself render it inequitable that he should be called upon to repay, because the expenditure might, in any event, have been incurred by him in the ordinary course of things. I fear that the mistaken assumption that mere expenditure of money may be regarded as amounting to a change of position for present purposes has led in the past to opposition by some to recognition of a defence which is in fact likely to be available only on comparatively rare occasions. So that's Lord Goth, the expressions of general principle. The defence is available to a person whose position has so changed that it would be inequitable in all the circumstances to require him to make restitution, or at least make restitution in full. And that, of course, has been refined in later authorities, which we'll come on to have a look at. But it's important and worth looking at what Lord Templeman had to say. And we can pick it up at paragraph 43H. Page 43, H, right at the bottom of the page. In the course of argument, there was a good deal of discussion concerning tracing in law and in equity. In my opinion, in a claim for money having received by a thief, the plaintiff victim must show that money belonged to him, was paid by the thief to the defendant, and that the defendant was unjustly enriched and remained unjustly enriched. An innocent recipient of stolen money may not be enriched at all. If Kath had paid £20,000 derived from the solicitors to a car dealer for a motor car priced at £20,000, the car dealer would not have been enriched. The car dealer would have received £20,000 for a car worth £20,000. But an innocent recipient of stolen money will be enriched if the recipient has not given full consideration. If Cass had given £20,000 of the solicitor's money to a friend as a gift, the friend would have been enriched and unjustly enriched because a donee of stolen money cannot, in good conscience, rely on the bounty of the thief to deny restitution to the victim of the theft. Complications arise if the donee innocent explains the stolen money in reliance on the validity of the gift before the donee receives notice of the victim's claim for restitution. And that, of course, is the sort of territory, well, that's the territory that Trafigura says that we are in. Thus, if the donee spent £20,000 in the purchase of a motor car which he would not have purchased but for the gift, it seems to me that the donee has altered his position on the faith of the gift and has only been unjustly enriched to the extent of the second-hand value of the motor car at the date when the victim of the theft seeks restitution. If the donee spends the £20,000 in a trip round the world, which he would not have undertaken without the gift, it seems to me that the donee has altered his position on the faith of the gift and that he is not unjustly enriched when the victim of the theft seeks restitution. And then he returns to the case in hand. And one of the reasons I've shown you that passage is because it gives some insight into how Lord Templeman approached the causative element of the change of position defence. Of course, you will have spotted the use of the words but for, but we also have, in the same passage, the notion of reliance on the validity of the gift and, I think at least twice, the use of the phrase on the faith of the gift. And what this case illustrates, in my submissions we'll come on to, is that the concept of but for and the concept of on the faith of the gift or reliance on the gift is actually different things. The point that Lord Templeman is seeking to capture, we submit, is that where the relevant change of position has come about through the voluntary act of the recipient, that change will need to have been brought about by a belief on the part of that person as to a particular state of affairs, which has been induced by the relevant payment. So that's Lipkin Gorman. I want also just to show you the more recent decision of this court in Haugesand Commune and Deptford, which contains the convenient summary of the principles. That's at tab 15 of the authorities bundle. We'll come back to look at this case in more detail, but for present purposes, we can look at how the principles were summarised by Lord Justice Aikins, with whom Lord Justice Pill agreed, and with whom Lord Justice Everton agreed so far as presently material. And we have that at page 425. So Lord Justice Aikins conducted a review of the authorities on change of position. He pulls the threads together at paragraph 122. I think that the following propositions are obvious from the foregoing analysis of the cases. First, the defence of change of position is a general defence to all restitution claims for money or other property based on unjust enrichment. Second, the question is always whether it is unjust to allow the claimant to have restitution in whole or in part. Third, that itself depends on whether the defendant has so changed his position that the injustice of requiring him to repay outweighs the injustice of denying the claimant restitution in whole or in part. That can only be decided on the facts of each individual case. So there's sort of balance of injustices, a concept with which the court is very familiar. Fourthly, a defendant cannot rely on this defence if he has acted in bad faith or has failed to show good faith, which is not the same thing as having acted dishonestly. And that's important, we'll come back to it. I have concluded also that cases draw a clear distinction between two different types of circumstance, at least where money is concerned. The first is where the defendant obtains or is about to obtain money in circumstances where he understands in good faith that it is his to keep and do what he likes with. Then the defendant spends the money in good faith on the basis of that understanding. That's not our case, as we've seen. The second type of case is where a defendant obtains money and at the time of receipt he understands that he will have to repay that sum at some stage in the future, which point has usually been identified between the payer and the payee, usually in a contract or what was at the time thought to be a valid contract. That's also not quite our case. We're in between, or we have elements of both. So, or let me put it more simply, we're different to both of those.
You may be coming back to this, but why do you say this is not a case where Trafigura understood in good faith. I understand your point about good faith. That the money was theirs to do what they liked with. That was what they understood. You say that's because of a TPA.
Yes.
But that was what they understood.
Yes, absolutely. And the question for your lordships and your ladyship is, what is the cause of that understanding? And the answer in my submission is the TPA, not the payment. So the critical thing is, is the understanding on the faith, to use Lord Templeman's phrase, on the faith of the payment, or is the understanding on the faith of the TPAs? And it's on the faith of the TPAs.
We'll no doubt come back to this, but an understanding would never be based on a payment itself. It must always be something around the payment.
Yes, so
I don't want to take you out of your
we're coming to that straight away, but can I answer your ladyship's question straight away? Yes, there will be a context in which the payment is received,
Yes.
and an understanding which arises out of that context. But the context in which the payment was received here, and the understanding that arose out of the receipt of the payment was, we need to take a further step. We need to get Rasmala's permission in order to use the payment in a particular way. So that's the context. The understanding that they could allocate and therefore change their position as they did was not something derived from the fact of the payment or the context of the payment. It was something derived from the fraud of Farlin in forging Rasmala's signature on the TPA. And that's the short causation point.
Entirely on the understanding that some additional step was thought to be needed, whether an actual TPA or in the case of payment 5, some sort of assumption that agreement would be forthcoming.
Yes, indeed. And if you, as it were, as with all analyses of causation, it's helpful to think about it in terms of step by step.
Well, yes, I can see that in the case of payment 1, you maybe have a sequential benefit, as in you can show us that they get the payment and they first understand it's for a future delivery, and then some arrangement is reached. That may not be so obvious in the case of payments 2 to 5.
My submission in relation to that is that the fact that in payment 1 they understood that it was not to be allocated, they had a positive understanding that it would to be allocated to future payments, and therefore if they didn't get consent from Rasmala to allocate it to past payments, they'd have to return it. That makes the point more starkly, but it is in my submission actually a bit of a red herring to distinguish between that and payments 2 to 5. If one actually thinks about what their state of mind was relevantly in relation to all 4 of the first 4 payments, when they received the payment, they understood that they needed to get consent from Rasmala to apply the payments to the accrued debt, or indeed anything, to do anything with it. They knew that they had to get consent from Rasmala to allocate the payment as they did, and therefore unlock the continued trading in with Farlin, which was the change of position. So that's the submission. I take your ladyship's point entirely that it's more starkly presented in relation to payment 1, because their understanding of the payer's intention was actually contrary to what they ultimately did and wanted to do with the payment.
But going back to the start of my question, obviously any payment is made in context.
Yes.
For your argument to succeed, you have to effectively divorce from that context the TPA or the assumption that you will get a TPA.
Well, it depends what one means by divorce from the context, but we have to submit that the TPA is the cause, not the payment. And we'll come on to this in a moment, but what we submit is that the judge elides the two. He elides the payment and the TPA, and he fails to recognise that they are distinct steps, and that the critical causative step was the TPA. So this isn't a situation where you receive a payment in a particular context which you then sort of reasonably rely on. This is a situation where something else has to happen, as you know it has to happen when you receive the payment, and then it does happen. The question is whether that further something else is the causative element that brings about the change of position. We submit it does. Can I take
just before you move on,
Yes, cool.
pick up a point I made, is that you accepted that the position in relation to payment one is, as you put it, more stark. On the figures, are you pursuing a claim to payment one?
Exactly.
Because I understood you to say earlier that you'd made £22 million of payments, but that you were only pursuing 11 million odd in this appeal, and that's because you don't challenge the judge's final remark that the allocation of the 10 point something million which had been received, you couldn't reallocate, and that
Yes.
10 point something, he says, was received in respect to payments 1 and 2.
1 and 2, indeed.
And
I think-
payment 1 is 6.8 million odd. So if you and payment 2 is about 4.3. So do you accept that 10 point whatever it is has discharged any claim in relation to payment 1 in its entirety and most of payment 2, or do you say that it's discharged most of payment 1 and most of payment? I mean, what is the position? What are you actually claiming?
Can I take some instruction on
Yes.
that over lunch and get back to my law?
I mean, it
I think the answer may be yes,
It
but
presumably also affects such things as the calculation of interest. If your claim is a good one, you would claim interest, but
Yes.
only from when you make the payment. So
undoubtedly.
I think we do, with respect, need to know which payments you say you're entitled to restitution.
Perfectly
of.
fair. Perfectly fair of your lordship to raise it. I'll take instructions over lunch in relation to that. But your lordship has the point that payment 1 is more stark, but the distinction between payment 1 and payment
Oh, I understand both why you say it's more stark and why you say you still maintain the claim in relation to payments 2 to 5. Yes.
Yes. So let's have a look at the judge's findings on causation. We can pick it up at paragraph 93. Which is at page 89. A defendant can escape liability in just enrichment where his position is so changed that it would be inexplicable in all the circumstances to require him to make restitution or alternatively restitution in full. That's Licht and Gorman, we've seen that. The defence is established in respect of a mistaken payment if the defendant has in good faith changed his position in some way which, but for the payment, he would not have done, and he will now suffer substantial detriment if required to repay all or alternatively part of the sum received. And the reference there is to a judgment of Justice Gagler in the High Court of Australia. We have that. I'm not going to, in light of the time, spend too much time on it. Perhaps we can just very quickly turn it up. It is at tab 9 of the authorities bundle.
19, I think.
I'm so sorry, 19 of the authorities bundle. What I just invite you to note is that, first of all, this is not the judgment of the majority. So the majority judgment starts at page 634. So sorry, the majority starts at 621. And there you've got 5 of the justices. So Gagler is not a part of the majority. And if one actually looks at the paragraphs that are referred to, paragraphs 157 and 158 in the judge's judgment, there's no mention of but for in those paragraphs at all. Then reading on in the judge's judgment, there must be a relevant causal connection between the enrichment and the change of position. Subjective knowledge of and voluntary action in reliance upon an enrichment is not necessary. It is sufficient that the defendant's position has materially altered and the enrichment has caused the change of position. And then there's a reference to the council judgment in Delta Petroleum. However, it follows that where the change of position has been caused by voluntary action, the voluntary action must have been caused by the enrichment. And that is our case, and we respectfully agree with that. The change of position here was caused by Trafigura's voluntary action in carrying on trading with Falk. So reading on in the judgment, Rasmala contends that Trafigura relied on the TPAs to discharge Farland's historic sets, and so its change of position was caused by the TPAs and not the receipt of the payments. In relation to payment 1, Trafigura knew that Rasmala had not made the payment to discharge Farland's historic debts. Trafigura's witnesses confirmed that if Farland had not provided the TPA purportedly signed by Rasmala for payment 1, the payment would have been returned to Rasmala, and we've looked at that. Rasmala relies upon the case of Rose. In that case, the defendant bank released a legal charge on the basis that payments received by it from its customer company had discharged the company's overdraft, even though it knew that the liquidator of the customer company had a good restitutionary claim for the return of those payments. Warren J, it's not quite right actually, he was sitting as a deputy at that stage, rejected the bank's change of position on 2 alternative grounds. Firstly, since the bank had known when it released the charge that there was least significant exposure to a restitutionary claim by the liquidator, its change of position in releasing the charge, albeit in good faith, had been made in reliance not on the initial validity of the credits to the overdrawn account, but on an assumption that the liquidator would not make a claim to assert their invalidity. Secondly, and alternatively, that the bank had taken a risk that its assumption that no claim would be made was wrong and it could not complain when the risk became a reality. Rose is a case where what had caused the change of position is not the payment, which the defendant knew was invalid, but the belief that the claim would not be enforced. What Rose shows is that where the change of position is caused by voluntary action, then it will be a question of fact whether that voluntary action was caused by the payment or by something else. Now, just pausing there for a moment, we'll come on to look at the decision in Rose in some detail, but for present purposes, I would just ask you to note that even on the judge's short summary of the case, one can see that the application of a but-for causation test in Rose would have led to a different conclusion than the one arrived at. In that case, but for the payment, the charge would not have been released. But the court nonetheless concluded that the cause of the change of position was not the payments, but the defendant's belief, assumption, that any claim to them would not be enforced. And the judge recognised that distinction in paragraph 97. He didn't suggest that the decision in Rose was wrong, but we submit he didn't apply the logic of the distinction to the analysis of the case before us. So returning to the judgment, we can pick it up at paragraph 98. Trafigura says that the payments caused Trafigura to continue to trade with and supply coal to Farlin. Trafigura's witnesses, such as Mr. Maru, were clear, and I accept that if the payments had not been made, further deliveries to Farlin would not have been made because they would have exceeded Farlin's credit limit with Trafigura. There's an example of this happening, and then he refers to a particular shipment. And then 99, TPAs are not common or standard practice in the industry, but it's Trafigura's policy to have them whenever it receives a payment from a third party. Okay, I think that's the point my lady referred to earlier. They gave Trafigura a contractual right as against Rasmala and Farlin to treat payment from Rasmala as payment on behalf of Farlin in respect of a specified contract. They avoided misunderstanding and provided transparency as to how Trafigura would deal with the monies as it received. But had there been no payment, there would have been no TPA. The TPA was simply a step Trafigura required to process the payment it had received or was to receive. What caused Trafigura to continue to trade with Farlin was that it had received a payment on what it considered were satisfactory terms as to how it could use that payment. That is a sufficient causal connection between the enrichment and the change of position. That, of course, is the critical paragraph, and we submit it's flawed in at least two respects. Firstly, consistently with the heading of this section of the judgment, the judge appears to approach matters on the basis that since but for the payments there would have been no TPA and therefore no change of position, the necessary cause had been shown. That seems to be what the judge is saying when he notes that had there been no payment there would have been no TPA in the middle of the paragraph. And that, we say, is the wrong approach. Secondly, the judge allied two different matters in his analysis, which we see from the sentence which reads, what caused Trafigura to continue to trade with Farlin was that it had received a payment on what it considered were satisfactory terms as to how it could use that payment. That elides the fact of the receipt of the payments and whatever circumstances surrounded that receipt, with the belief held by Trafigura as to how it could use the payments. It was the belief that the payments could be used to pay down the accrued debt that was critical, and that belief was not brought about by the receipt of the payments themselves. It was brought about by something else, namely the TPAs, or in the case of payment 5, an assumption that the TPA would be forthcoming. That elision may not matter on a strict but-for approach, but we say that that approach is wrong in a case such as this. And paragraphs 101 and 102 of the judgment, which finish off the section on this section of the judgment, are concerned with the concept of risk allocation, and specifically in 102 with payment 5, and we will come back to them when we consider that aspect of the appeal in due course.
So do you want just to say what you think is precisely wrong with the penultimate sentence in 99?
Yes, so what caused Trafigura to continue to trade with Farlin was not that it had received a payment on what it considered were satisfactory terms as how it could use that payment. When it received the payment, it had not received the payment on satisfactory terms in its own mind. When Trafigura received payments 1, 2, 3, 4 and 5, its belief, its understanding was that something else had to happen before it could allocate the payment in the way it wished to enable it to carry on trading with Farling. That something else was the TPA, or in the case of payment 5, an assumption that a TPA would be forthcoming, and it is that which is the cause of the change of position, because it is that which generated the belief that Trafigura had allocated the payments to pay down the debt, and it is that belief which caused it to carry on trading with Farling. So that's the causation case.
Right.
Now, I said that I'd take you to Rose. It's at tab 9 of the authorities bundle, and it's the authority which the judge refers to in relation to this part of his judgment. If we go to tab 9, page 263, so this is a decision of Nicholas Warren QC, as he then was sitting as a deputy High Court judge. The facts were reasonably straightforward, and the head note contains a sensible summary. A creditor petitioned in February 97 for a company to be wound up on the ground that it was unable to pay its debts. At the date of presentation of the petition, the company's accounts with its bank were overdrawn. The bank's liability was secured by a legal charge over property belonging to the company's sole director and shareholder. The bank did not learn of the existence of the petition until it was advertised in September 97, by which time the company had paid off its debts to the bank in what the bank believed to be the ordinary course of business. The court made a compulsory winding up order. In December 97, a liquidator was appointed. In March 98, the liquidator stated that his investigation would be finished within 3 months and proceedings would follow within a year. In January 99, the bank released the charge, assuming that all the company's liabilities to it had been validly discharged. In September 82, the liquidator applied for declarations that the company's payments to the bank and to another creditor from the date of presentation up to the amount of its indebtedness to each of them at that date were void, pursuant to section 137 of the Insolvency Act, and for orders that those amounts be repaid to the liquidator. The bank resisted the claim on the grounds that payment into an overdraw bank account did not constitute a disposition for the purpose of section 127, that by releasing the charge the bank had changed its position and the court should therefore exercise its discretion under the section to validate the company's payments, and even if a validation order could not be made, the bank nevertheless had a defence to the liquidator's claim as a result of its change of position. And then held, granting the application, that where payment was made into a bank account which was overdrawn, there was a disposition of the customer's property in favour of the bank for the purposes of the section, and therefore section 127 rendered the payments void unless the court validated them. And then 2, that change of position could afford a defence to a liquidator's claim in restitution arising from dispositions having been rendered void by section 127, but that since the bank had known when it released the charge that there was at least significant exposure to a restitutionary claim by the liquidator, its change of position in releasing the charge, albeit in good faith, had been made in reliance not on the initial validity of the credits to the overdrawn account, but on an assumption that the liquidator would not make a claim to assert their invalidity, and so, absence of clear representation by the liquidator, sufficient to give rise to an estoppel that the company's debt to the bank had been validly discharged, did not give rise to a defence. That alternatively, the bank had taken a risk that its assumption that no claim would be made was wrong, and it could not complain with when the risk became a reality, that any fault on the part of the liquidator in delaying making the application was immaterial, and that accordingly the bank's change of position did not afford a defence to the liquidator's restitutionary claim or justify making an order under section 127 validating the payments.
This was a case where factually there was quite a long gap between the payments being made, certainly before the petition was advertised, because it says by which time the debts were paid, and the liquidator saying he was going through the process. And then it seems to be at least around about 15-18 months before the charge was released during the liquidation process.
Yeah, that is right, but in our we say immaterial. The two, I'll take you to the relevant passages, but just to, as it were, lay out my story. 2 points. One is clearly, but for doesn't work here. But clearly, it could be said that but for the payments, the bank wouldn't have released the charge, but that did not provide a sufficient causative link. And secondly, this is a case where the bank changed its position on the basis of a belief, a state of mind, and that belief was generated by its own assumption that the liquidator wouldn't pursue the invalidity of the payments. Now,
the belief had nothing to do with the original payment being made. Those payments were made.
it absolutely did, in my submission. If the payments hadn't been made, the bank would not have needed to form a belief at all. It's the payments which led to the belief. It's the payments which generated the need for the bank to form a view as to whether the liquidator would recover them or not. But for the payments, there would have been no need to form a belief, but for the payments.
No, I understand your point at that point on but for,
Yeah.
in the sense that the payments are a necessary starting point, as it were. But I'm at this stage simply trying to understand the facts of it better.
Well, can I show you the passages that I wanted to take you to in the judgment? That might help, and then we can come back to my lady. Unless you want me to deal with
No,
the point further now, I'm very happy to deal with whatever you want to ask.
I'll just see if I've understood it. It's by the time the bank released the charge, in I think March 1998, it knew perfectly well that it had received monies in breach of section 127. So unless it could get a validation, the liquidator had an unanswerable claim to the money back.
Yeah,
so it's the bank's, at the time that it released a charge, which is what it relies on to change its position, did know all the facts which made the restitution claim a good one. Is that not right?
It is. But the reason it changed its position was because it believed that the liquidator, for reasonable reasons,
Wouldn't
the
pursue it.
liquidator had sat on his hands,
Yeah.
that
Yes.
it believed that the liquidator wouldn't pursue it. And that leads to two different ways of analysing it, which the judge deals with both. One is causatively, what causes the change of position is not the payments, it's a belief that the bank bank formed that the liquidator is not going to pursue the payments. And the second way of analysing it is that the liquidator took the risk. It operated on an assumption that the bank took the risk. The bank operated, the recipient operated on an assumption that the liquidator would not come after the monies.
So this is all going to be illustrated by the passages that you're going to take.
I'll take you there now. So we can start at page 277, paragraph 47. So the judge makes clear fault doesn't matter. He said, as to good faith, there's nothing to suggest that the bank acted other than in good faith, whatever view one might take of the care with which it acted. There is certainly nothing to suggest that the bank released the charge over Mr. Bernard's house, believing that there was a debt owing, or did so recklessly, not caring whether there was a debt owing or not. And then perhaps we can just glance through the rest of it, which I think deals with my Lord Justice Nugee's point. Then paragraph 48. Suppose that the liquidator had made a claim in restitution before the bank had released its charge over Mr. Bernard's house. Suppose that the bank had nonetheless released the charge. The bank could not then, of course, rely on its change of position, but that is not because it acted in bad faith, or even because it did not act in good faith, since it was perfectly entitled to take the action it did. Rather, it was because the bank would not have relied in any sense on the invalid payment to it in acting as it did in releasing the charge. This highlights another point. The wide statement of the general principle of the change of position defence by Lord Gough includes a change brought about by the action of another, e.g. theft by a thief or the money paid. The bank's alleged change of position, in contrast, took place as a result of its own act in releasing the charge. It therefore still needs to show that it changed its position on the faith of the validity of the receipt. I'll just invite you to note those words. We see their reflection of what Lord Temperament said. The defence would fail, for example, if the bank had taken a decision to release the security in order to preserve its commercial relationship with Mr. Bernard, or that it deliberately decided to take the risk of invalidity.
Sorry, despite the reference to Lord Gough, that's a quotation from Lord Templeman.
Yeah, Lord Templeman. Yeah, it is. On the faith, I believe we looked at that earlier, didn't we?
Yeah, we did.
It is not suggested by Mr. Chairman that the bank was generally unaware of Section 127. The bank's own evidence is that its procedures for ruling off a customer's account, etc. So the bank's aware of 127. That's 50. 51. There's no evidence the bank simply failed to address the position when it had learnt of the liquidator's position, and the judge presumed that it knew of the risk that the liquidator would seek invalidity. That's 51 and 52. And then 53, how then did the bank come to release the charge? It says that it assumed that nothing was owing by Tame to the bank when it released the charge. It can only believe that nothing was owing one of two ways. First, because it positively addressed the matters which Mr. Chairman relies on and concluded that it had every reason to believe that no claim would be made by the liquidator. Or second, because it simply overlooked the petition and the effect of Section 127. The limited evidence does not explain expressly which of these is the case. I do not think that I should presume that the bank was careless or negligent. In any event, the onus would be on the bank to establish a change of position. In the absence of evidence from the bank that it simply overlooked the petition and the effect of Section 127, I conclude that the bank reached the conclusion that nothing was owing because of the factors relied on by Mr. Chairman. It follows that the bank's assumption arose only because of its own interpretation of the actions, or rather lack of action, by the liquidator since his appointment. I have already held that the bank, once it had notice of the petition, must be taken to have known that the liquidator had a good claim against it. Alternatively, I have held that by the end of March 98, it knew that there was significant exposure to such a claim. In these circumstances, I do not think that the bank can be said to be relying on the validity of the credit to the overdrawn accounts when they were made. Rather, it has to recognise that it knew that the liquidator had a good restitutionary claim, alternatively that it knew at least of a significant risk that he had such a claim, and has to accept that it took the view that as a result of the matters relied on Mr. Cherryman, that claim was not going to be asserted, rather than that it was never was a good claim. In my judgment, the change of position in releasing the charge was not made in reliance upon the initial validity of the credits to the overdrawn accounts, but was made in reliance on the assumption that no claim would be made to assert that initial invalidity. Without reliance on the initial validity, there is no change of position defence to the restitutionary claim. This accords with principle. If A owes B a debt but thinks it is unlikely to be enforced, he may change his position in reliance on his belief. His change of position affords no defence to B's claim, even if he has been encouraged in his belief by lack of activity on the part of B. The same should apply where B's claim against A is a restitutionary claim to recover a payment to him, e.g. made under a misstated fact. Once A knows of that claim, he cannot then change his position in reliance on the validity of the payment to him, although he can do so in the belief that the claim will not be enforced. That might, in my judgment, ought not to afford a defence based on change of position. So in the present case, the bank, which must be taken to have known of the initial invalidity of the credits to the overdrawn accounts, or at least of a significant risk that that was so, cannot be heard to say that it relied on the validity of the credits. It knew that the credits were open to challenge, but formed the view that they would not in fact be challenged. The only justification the bank could have for assuming that nothing was owing to it. In my judgment, in the absence of a clear representation by the liquidator sufficient to give rise to an estoppel to the effect that no money was owing to the bank is not entitled to rely on the discharge of the charge over Mr. Bernard's house as affording a change of position defence. There was of course no such representation. So that's, as it were, looking at it through a causative lens. We then have this concept of risk, taking the risk at paragraph 58. If, contrary to the view which I have expressed, it goes too far to say that the bank did not, in changing its position, rely at all on the validity of the credits to the overdrawn account, there is an alternative approach which leads to the same result and which I would adopt. Under this approach, the bank may have acted in good faith, cannot rely on the change of position as a defence because it took a risk. Aware of the risk, it cannot complain when the risk becomes a reality. This risk was that the assumption, based on the conduct of the liquidator, that no claim would be made against it was wrong. That risk could have been easily eliminated by the bank confirming the position with the liquidator. Of course, as Mr. Cherryman said, the bank would have been unlikely to wish to provoke the liquidator into action. I suppose that one could say it wished to let that sleeping dog continue its lengthy slumber, but that is simply part of the risk assessment which the risk taker must take into account. So, pulling the points on Rose together, on any view, looking at it through a causation lens, on any view, but for causation doesn't work in this case. That's not the basis on which the judge is proceeding. He's proceeding on the, I can call it this, the Templeman on the face of the receipt basis. The change of position was not on the face of the receipt of the payments. The change of position was on the face of the belief that the liquidators would not seek to assert the invalidity of the payments made by the company to the bank. And in our case, the change of position, we say, was not on the face of the payments, but on the face of the belief that the payments could be used to pay down the accrued debts, which belief was brought about by the TPS. The causal link on the but-for basis was not sufficient. There is obviously this difference that in the case of Rose, the belief was self-induced. In our case, the belief on the part of Trafigura was induced by the fraud of Farnin. But causatively, that makes no difference, we submit. Causatively, the change of position in Rose was on the basis of the bank's belief. Causatively, the change of position here was on the basis of Trafigura's belief, and neither belief was on the face of the payments. What Rose also shows is that there are different ways of analysing the same question, and we'll come on to this question of taking the risk in a few moments, but you will immediately appreciate what I'm going to say about payment 5. Again, the bank acted in relation to releasing the charge in Rose on the basis of an assumption that the liquidator would not seek to invalid.
So you rely on the first thread of the analysis in Rose for the first 4 payments, and the second thread, the risk for the 5th payment.
We do, although in fact we say the risk allocation point
they're both
works
all the
across
way
for all
through.
of it, but it's particularly acute,
Yeah.
we say, in relation to payment 5, and I'll come back to that. Now, this was the authority which the judge referred to, and for the reasons I've submitted, the judge's analysis of it was incorrect in my respectful submission. I want to show you 2 further causation authorities.
Has Rose been considered in another case?
I don't believe it has, other than this case, of course.
Yes.
But it's particularly prominent in this case because it's the only causation decision which the judge goes into in any detail.
Right.
But I do want to show you 2 further causation cases which are relied on by my learned friends in their skeleton argument. The first is a case called Scottish Equitable and Derby. And this is a judgment of this court. It's at tab 6 of the authorities bundle. And yeah, it hasn't been allocated with, has it? Yeah, sorry, I should just clarify, I'm just checking with my learned junior. So Rose hasn't been referred to in later cases on the point we're currently on,
That's
which is
right,
causation, as I understood.
Yeah.
So
Yes.
paragraph, Scottish Equitable and Derby. This is a case where a Mr. Derby was living in a house worth £90,000 subject to a mortgage of £35,000 at the beginning of 1988. He was made redundant in the spring of 1988 and received a £125,000 payment, of which £90,000 seems to have been transferred into a Scottish Equitable pension policy. He exercised an early retirement option in 1990 and was paid a tax-free lump sum and an annual pension. And 5 years later, he inquired about his pension and wanted it to be paid. Scottish Equitable mistakenly valued his pension at £201,000, and that was a very significant error because they failed to take into account the early retirement benefits which he had taken in 1990, which should have only left £29,500. Mr. Derby was therefore overpaid approximately £172,000, and with that money used £41,000 odd to pay off his mortgage and about £9,000 on modest lifestyle improvements. And Robert Walker, Lord Justice Robert Walker, as he then was, gave the lead judgment, and the rest of the court agreed with his judgment. And the first question for the court was, sorry, I should say, and the Scottish Equitable sought restitution of the overpayment. That's how the case comes back. And the first question for the court was to what extent, if at all, carelessness on the part of the payer matters, and the answer is it doesn't. The key issue in the case was whether Mr. Derby had a change of position defence, and that was addressed at page 199, starting at the bottom of the page, as you can see. And the judge summarised Lord Gough's speech in Lipkin-Gorman, excuse me. He then came on to what the first instance judge had said about the defence of change of position, and he dealt with that at paragraph 30 over on page 201. And we'll come back to these passages in a moment because they're relied on, I think, by my learned friends. In the event, Lord Justice Robert Walker rejected the change of position defence, except in relation to the around £9,000 Mr. Derby had spent on lifestyle improvements, and he does that at paragraph 34 onwards. Essentially, he says the paying off of the mortgage wasn't a change of position because he'd got to do that anyway. He was going to do that anyway, so it wasn't a change of position. But the £9,000 spent on the lifestyle improvement was, because he would not have done that if he hadn't been overpaid. Now, if we go back to paragraphs 30 and 31, and these paragraphs have been relied on by my learned friends and indeed are cited in various textbooks. The judge noted sorry, I'm just reading from paragraph 30. The judge noted the view put forward by Andrew Burrows, as he then was, that there is a narrow and wide version of the defence of change of position and that the wide view is to be preferred. The narrow view treats the defence as the same as estoppel minus the representation, so that detrimental reliance is still a necessary ingredient. The wide view looks to a change of position causally linked to the mistaken receipt, which makes it inequitable for the recipient to be required to make restitution. In many cases, either test produces the same result, but the wide view extends protection to, for instance, an innocent recipient of a payment which is later stolen from him. In this court, Mr. Stephen Moriarty QC, appearing with Mr. Richard Handyside for Scottish Equitable, did not argue against the correctness of the wide view, provided that the need for a sufficient causal link is clearly recognised. The fact that the recipient may have suffered some misfortune, such as a breakdown in his health or the loss of his job, is not a defence unless the misfortune is causally linked, at least on a but-for test, with the mistaken receipt. And those are the words relied on by the respondent. In my view, Mr. Moriarty was right to make that concession. Taking a wide view of the scope of the defence facilitates a more generous approach to the recognition of the right to restitution. And then there's reference to Lipkin Gorman and also Kleinworth Benson. Now, we submit that the following points fall to be made, and a brief reference to the but-for test as we see it in the context of the change of position defence does not support the weight which my learned friends seek to place on it. First of all, the points being dealt with, as you see, by way of a concession, and for that reason, no doubt, there is no detailed consideration of the matter. Secondly, that observation was in fact obiter, because the change of position defence had been rejected on grounds not concerned with causation, save in respect of the £9,000 odd expenditure in relation to which no causation point appears to have arisen, which again is another reason, no doubt, why no detailed consideration was given. Third, the language used in paragraph 31 is that there must be a causal link at least on a but-for test. That, of course, is somewhat ambiguous, but it can be read as Lord Justice Robert Walker leaving his options open and simply expressing the view that the causation test will be at least a but-for test, but maybe a higher threshold. That, of course, would be consistent with the understandably exiguous treatment the matter is given in this passage. And fourthly, the observation was made in the context of a debate summarised at paragraph 30 between the wide view and the narrow view of the defence. And that debate appears to have been concerned with the question of whether restitution could be claimed where the relevant change of position was not the result of the voluntary act of the recipient at all, such as where there was an immediate disenrichment by way of a theft. That's a different context, at least, to that in which the relevant change of position has been brought about by the voluntary act of the recipient. Indeed, in the case of a theft, it's, in my submission, inapposite to talk about the defendant having changed its position at all.
Well, its position has been changed for it.
Yes, but it hasn't changed its position. It's simply not incurred an enrichment.
But it could still make it inequitable. I mean, if you pose the general question, if you have to give the money back, will you now be worse off than if you'd never had it?
Yes.
The answer is yes, if someone's stolen it.
It is a debate, mercifully, which we don't need to get into in this case.
Well,
You say
Mr. Kitchener's body language suggests he doesn't agree with that.
you say that, but
Calm down.
Well, I look forward to it. One of the ways in which that situation has been analysed is one of disenrichment, as your lordship will no doubt appreciate. In other words,
I do appreciate it. It's not a word I recognise, although I see that it has been used in at least one judgment.
yeah.
Is there a better word for disenrichment?
not one that I can think of now, but
No.
I can try at 2 o'clock.
Yes.
But not that's been used in the textbooks or the authorities. It's simply that where the money's been paid over and then stolen, the proper approach is to regard the enrichment as either not having happened or no longer pertaining. in
So
that
you
sort
mean
of
it's
case.
not a change of position example at all? It's just no unjust enrichment.
Exactly.
Okay.
That's a coherent way of analysing it.
Can I don't know if this now is a convenient moment, but I want to ask what your test is on causation.
So we
Proposed test.
we would say in a case such as this where you've got a voluntary action, the change of position is comes about as a result of a voluntary action of the recipient. That voluntary action has to be on the face of the receipt. So, in other words,
On the face
on
of
the face
on the face of the
on
receipt.
the face of the receipt. So that's Lord.
Picking up what Lord Templeman said, he wasn't in the majority. Was he? Or
No, he
They-
was agreed with by he was.
They all agree with both.
do
don't
they
They agree with both, yes.
Okay.
Lord Goff doesn't say anything different. Lord Goff doesn't really go into the
So
question.
he has that broad principle as to whether it's inequitable.
broad principles as to whether it's inequitable. And I'll come on to in a moment to explain why we say that rather than a but-for approach is more consistent with those broad Lord Goff principles.
But you do need to tease out what on faith of the receipt means, because if it simply means in the belief that the money is yours, then on your facts, a Trafigura did believe the money was yours. You have to add in the belief that the money is yours because it's been paid to you,
Yes.
and not because of anything else.
Yes.
That's really what you mean.
Yeah, we say it's on the face of the receipt rather than on the face of something else. I mean, there's a danger of overcomplicating these things. The analysis, the correct analysis in this case, we say, is that Trafigura changed its position on the face of the TPAs. It did not change its position on the face of the receipt.
Well, it changes its position on the face of both. It received some money and it thought that it could spend it as it wanted. And you say that it's not enough that part of the reason why it thought it could spend the money was because it had been paid the money. You have to look at the TPAs, which was another part of why it thought it could spend the money, because just receiving the money on the evidence, you say, wouldn't have led Trafigura to think that it could spend the money.
Exactly.
Without the TPA, Trafigura would not have been entitled to spend the money. Is that yours?
Without the TPA, Trafigura would not have believed it was entitled to
Yes.
spend the money and would have returned it. So
Just if there'd never been a TPA, what would have happened?
they'd have returned it. That was the evidence. If there'd never been a TPA, the evidence, we looked at what Mr. Maru said and Mr. Gokal, not just in relation to payment 1, but payments 2, 3, 4, and in fact 5, and we'll come on to that in a moment. If they hadn't received a TPA, then the money would have been returned,
Why?
because they would not have formed the belief that they were authorised to allocate the monies as they did.
Why? Because when they received the payment, what was their state of mind?
When they received the payment, their state of mind was, we've received a payment from an unknown third party, we need authority. I mean, this is right, as it happens, as a matter of law, it's right. We need authority to allocate that payment as we wish to allocate it from the payer. I mean, if
Is that right?
Well-
You say that's right. I mean, I know that.
They proceeded. I mean, the evidence and the findings you've showed us, it do indicate that they proceeded on that basis.
Yes.
There's not much
they certainly
debate
proceed
about
on that
whether
basis,
it's-
but I mean, just pausing for a moment, let's assume that all that happened was that they received the money. Nothing else. There's just a big dollop of money lands into their bank account. And then they dealt with it in what way they thought fit. They clearly wouldn't have a change of position defence in that circumstance.
Why not? If you
Because-
receive money into your account, don't you assume
Because
it's
they've got,
yours?
they've got
Don't you assume the person paying it assumes you're meant to have it?
One would hope not, in my submission. If you receive money from an unknown third party into your bank account for purposes of which you are entirely unaware, one would hope that you would contact the third party and try and work out what it was doing.
But that's
in
not
your
the
bank
position here, is it?
Sorry?
Is that the position here?
No, it isn't the position.
No.
here, but I'm just,
I think there's a
was just
danger.
testing the.
Yeah, no,
Well-
I understand why everybody's asking these questions, and I understand why you take us to the authorities. But in fact, the facts are different.
They are
They're
different.
different from what the laws just put to you. They're different from what was in Rose, and they're different from what was in Scottish Equitable.
Absolutely, we are
So-
in uncharted territory. But in my submission, where this is a case where the change of position is a result of a voluntary action, which is itself the result of a belief, and you have to ask yourself, what was the cause of the belief?
Yeah.
And the cause of the belief in my submission was the TPA. True it is, as the judge observed, and as my Lord Justice Nugee made the point to me earlier, true it is that the payments lead to the TPA.
Yes.
True it is that if the payments hadn't been made, the context for the TPA coming about would not have arisen. But we say that doesn't matter. You've got to ask yourself, what is the cause? It's the belief, and the belief is generated by the TPA.
So the question is, what was the state of mind of Trafigura at the time they got the payment? And what was the state of mind when they received the TPA?
Yes.
That's your point.
And it is entirely my point. And the answer to those two questions is, at the time it got the payment, it did not think it could use the money in the way that it wished.
But for the TPA, it wouldn't have been it. in other
That's
words.
one way of putting it.
Yeah.
That may muddy the waters.
Just going back to what you described as the wide and narrow version.
Yes.
You're arguing really for
It's a debate I hope
30.
to be able to sidestep.
I'm not sure you can.
Certainly, if the right view is the narrow version, and you're talking about reliance simpliciter, then that makes out my case, we would say. But I would draw a distinction between the wide version, which is looking at things from the perspective. Let me take a step back. Why is the wide version favoured? The wide version is favoured because it's thought that if somebody receives a payment and then it's stolen, or receives an asset and then it immediately goes on fire, then it would be inequitable to force them to
Fine.
repay the value.
So that's why you're trying to formulate what you put in terms of voluntary payments. But what I'm driving at is really whether that distinction is certainly the theft point is made as an example in the context of justifying the so-called wide approach. It's not put here, at least, as a principled basis for distinction. I think you're trying to articulate a rule that would be different in the case of theft and voluntary.
I think I'm trying to articulate a rule that would be different in the case of what I have probably inelegantly described as disenrichment.
But the underlying philosophy, and you made this point right at the start, is what's equitable or inequitable.
It is. And my submission, perhaps I can come on to this, my submission, although we do need to look at another authority, is that if you're balancing the equities between as in most cases, as in this case, neither party is at fault, or they're equally at fault. This is a case where you've got a fraudster and two victims. There's a question of who bears the loss. If you're balancing the equities, we submit that the more distant the causal link between the payment and the change of position, the less inequitable it is to require repayment, and the more inequitable it is to deprive restitution.
Can you say that again?
The more, let me.
I repeated it 2 o'clock probably.
Yes.
Can I, if we're looking at things for you to think about over the short term, can I put this to you? If you accept the wide view, you receive £100,000 into your bank account, and you think that you're entitled to it. Someone steals it from you. You don't have to give it back. Suppose you receive £100,000 into your bank account, and you think you're entitled to it, and then someone defrauds you of it, and you make a payment because you've been swindled out of it. Do you have to give it back?
Well, that would depend on the circumstances, but I think very well.
I think that's probably
Good
the
answer.
answer.
Good answer. Can I maybe you need to. Should we pause there rather than asking you to repeat your submission, which you've probably forgot what you said, unless you.
Well, no,
You
I will
put it
read
in,
it
you
out,
put it in an
and I'm
elegant,
going to come back to
an
it, 'cause-
elegant sentence, which I want you to write down what your case
Yes,
is.
what you're really trying to look for is a principal basis
Yeah.
for the approach that we commend, as opposed to the approach that is commended by the other side. And what we say is, where the relevant events comprise the greater the causative distance
That's right. Yeah.
between the payer's mistake and the recipient's change of position, the greater the injustice of depriving the payer of restitution, and the lesser the injustice of requiring restitution by the payee.
Right.
And we'll come back to that
Yes.
after lunch, but I'm going to plant that thought in your mind.
Thank you very much. It's
And
planted.
we'll see if it grows. Or
Can I just comment? It doesn't seem a very precise test.
Seem more precise when you said it first time than when you said it second time.
No,
Yes.
the
That's my
test
cross-examination
is on the
test.
faith of the payment. What I'm trying to
The
articulate
test is on the faith of the payment in the sense that it's the payment which makes you think it's yours to do
Exactly.
what you like with.
Exactly.
On the faith of the payment and nothing else.
Well, nothing else that happens later, rather than is part of the circumstances of the payment. Yes.
Can I ask this? Paragraphs 30 and 31 of Scottish Extra Law bookended by reference to Lord Burroughs' book, paragraph 30, and a reference to a second judgment of Lord Gough at the end of 31. Do we need to look at either of those?
I don't think you do. I don't think we've actually got Lord Burroughs' book in the.
We've got some of it.
I think
Oh,
we may, actually.
we've got Climate Benson, have we?
No,
Okay, well, anyway,
Tab 26 has got
yes,
a couple of
we've got
pages,
some
but-
Burroughs, Virgo, and Gough and Jones.
Yes. I'm not sure we've got this edition of Burroughs though.
No, we don't, but we have him making the
so
same
they
point.
so Mr. Kitchener's got the academics on his side. He's just letting us know.
No. Well, I mean, my submission absolutely not. But we'll come back.
Let's pause before we come to anarchic, and we'll resume at 2 o'clock.